Hello and welcome, dear students. Today our topic of deliberation is maintenance under Criminal Procedure Code 1973. First, its objectives. To understand the law of maintenance. To understand the nature of proceedings under Section 125 Criminal Procedure Code. To understand whether the law applies to all the communities. To understand the main objects of Section 125 to 128 Criminal Procedure Code. The chapter on maintenance of wives, children and parents are aimed to help the people who are destitute and are unable to maintain themselves. This is basically a social welfare legislation which is aimed to remove vagrancy in the society. The aim of this chapter in Criminal Procedure Code is to help old people, women and children who cannot maintain themselves due to the financial constraints. Section 125 to 128 Criminal Procedure Code cast upon a duty on every individual for maintenance of above-mentioned persons. These provisions in Criminal Procedure Code are made to help destitute wives, deserted children and old and infirm parents. These sections provide speedy, effective and inexpensive remedy to the affected persons. Sections 125 to 128 apply to all persons irrespective of their religious beliefs, and in order to give judicial character to the proceedings, the power is vested with judicial magistrate. These sections provide a self-contained procedure which is simple to handle the cases of such persons who are in need of maintenance. Though the proceedings under these sections are of civil nature, the parties can agitate against the orders of judicial magistrate before the civil court as well. As it was observed in the case of W.L. Misra versus K.L. Misra, the main provisions of Section 125 of Criminal Procedure Code are as under. Number 1. If any person having sufficient means neglects or refuses to maintain A. His wife unable to maintain herself, or B. His legitimate or illegitimate minor child, whether married or not, unable to maintain itself, or C. His legitimate or illegitimate child, not being a married daughter who has attained majority, where such child is by reason of any physical or mental abnormality or injury unable to maintain itself, or D. His father or mother unable to maintain himself or herself. A magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife or such child, father or mother, at such monthly rate not exceeding as magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct, provided that the magistrate may order the father of a minor female child referred to in clause B to make such allowance until she attains her majority, if the magistrate is satisfied that the husband of such minor female child, if married, is not possessed of sufficient means. Explanation. For the purposes of this chapter, A. Minor means a person who, under the provisions of the Indian Majority Act 1875, is deemed not to have attained his majority. B. Wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried. Number 2. Such allowance shall be payable from the date of the order, or if so ordered, from the date of the application for maintenance. Number 3. If any person so ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issued a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole or any part of each month's allowances remaining unpaid after the execution of the warrant to imprisonment for a term which may extend to 1 month or until payment if sooner made. Provided that no warrant shall be issued for the recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it became due. Provided further that if such person offers to maintain his wife on condition of her living with him and she refuses to live with him, such magistrate may consider any grounds of refusal stated by her and may make an order under this section notwithstanding such offer, if he is satisfied that there is just ground for so doing. Explanation: if a husband has contracted marriage with another woman or keeps a mistress, it shall be considered to be just ground for his wife's refusal to live with him. Number 4. No wife shall be entitled to receive an allowance from her husband under this section if she is living in adultery or if without any sufficient reason she refuses to live with her husband or if they are living separately by mutual consent. Number 5. On proof that any wife in whose favor an order has been made under this section is living in adultery or that without sufficient reason she refuses to live with her husband or that they are living separately by mutual consent, the magistrate shall cancel the order. But in order to claim maintenance under section 125, the woman should be legally wedded wife under the law applicable to her as it was held in the case of Yamuna Bai versus Anant Roy. A woman who wants to agitate her right of maintenance can do so either under this section or by raising the claim before the civil court. The proceedings under section 125 cannot be allowed if the civil suit for the same purpose is pending before the civil court. The court in Ravinder versus Shaila Karmakar held that the decision of the civil court will prevail over the section 125. Any person, the word person under this section includes both male and female. Under this section, the proceedings cannot be initiated against the whole family if male is the member of the joint family. The court will pass the maintenance order against the husband and not against the whole family. In Rajkumari versus Yashoda Devi, the court laid down that the person under section 125 does include father or son or husband, but does not include daughter, mother or wife. A married daughter will be included in the word person. A person is supposed to maintain his wife, children or parents when he has sufficient means. The word sufficient means not only actual pecuniary resources, but it has reference to the earning capacity. If the wife does refer to the sufficient means of husband, it does not take away the right of the woman to claim the right of maintenance. The means provided in section 125 does not only mean the visible means like land or property, but it includes his capacity to work as an able-bodied person. The court in Basanta Kumar versus Sarat Kumar has gone to the extent that even a beggar, monk or a minor has to maintain his wife if he is able-bodied and can earn his livelihood. Refusal to maintenance. The aggrieved party can file a case under section 125 Criminal Procedure Code if the other party is refusing to maintain him or her, or if he neglects to maintain the wife, children or parents. The refusal can be either implied or express, or it can be by means of conduct or by words. The refusal means when the person is neglecting to maintain the person, where a husband asks the wife to live with his mistress, and if the wife refuses to live, then it will amount to refusal to maintenance. Maintenance means providing food, shelter and the normal facilities of life. Refusal of the first wife to live with the husband who has contracted second marriage will mean the negligence for purposes of this section. The court in Chand Begum versus Haider Beg that the refusing to live with the husband in presence of second wife will result to refusal to maintenance. But a wife who refuses to live with the husband without any reason cannot claim the maintenance. The following persons will be entitled to maintenance under Section 125 Criminal Procedure Code. A. Wife. A husband is under the legal obligation to maintain his wife, but under Section 125, subsection 1, wife means only the legally wedded wife and does not include a concubine. If a man and woman are living together as husband and wife to the knowledge of public, she cannot claim the right under this section. The explanation B attached with section 125 subsection 1 makes it clear that the word wife includes a divorced wife as well. A wife will not be a divorcee unless she is legally married with the man. This argument has been strengthened by number of decisions given by various courts. This contention has been accepted even by the Supreme Court. The Supreme Court in Yamuna versus Anant Rao held that the legal validity of marriage would be determined by the personal laws applicable to parties. The Supreme Court in Vimla versus Veeraswamy held that the burden of proving that a marriage is invalid is on the husband and he has to prove it. The court in Naurang Singh versus Sapla Devi held that where it is proved that the marriage is illegal, the wife cannot claim the maintenance. The Kerala High Court in Kamgyan case laid down that wife will also include a divorced wife and includes cases where divorce is given by consent. The court in Zohra Khatun versus Muhammad Ibrahim held that a divorced wife is entitled to maintenance till she remarries. The same way was reiterated in the case of Muhammad Ahmad Khan versus Shah Banu Begum. The court said that a divorced Muslim woman till she does not marry will be treated as wife and she can enjoy the statutory right given to her under this section. But due to the criticism of this decision by Muslims, the Parliament has to enact a new law known as Muslim Women Protection of Rights on Divorce Act 1986 to undo the effects of the decision of the Supreme Court in Shah Banu case. B. Children. The other categories of person who are to be maintained by a person, father, are the children. The children include both legitimate and illegitimate children who are minor. It is not material whether he or she is married or not. The child under Section 125 Criminal Procedure Code means a minor who has not attained the age of majority as prescribed under Indian Majority Act, that is, who has not attained 18 years of age. But under Section 125, subsection 1, clause C, the benefit is available to even the children who has attained age of majority but by reason of mental disability or injury is unable to maintain themselves. The Supreme Court in Sumitra Devi versus Bai Khan Chaudhary held that to award the maintenance. Under this section, it is immaterial whether the child is legitimate or illegitimate, but before grant of maintenance, the child has to establish his paternity beyond doubt. The Punjab and Haryana High Court in Balbir Singh versus Hardeep Singh lays down the following principle if the children is living and are in custody of the mother as under. A. If the children are living with the mother who is living separately, the children are entitled to maintenance. B. When the father is natural guardian and the child is living with mother, father has to pay the maintenance and he cannot insist the child should live with him. C. In case the father does not want to maintain the child when the child is in mother's custody, he should get the custody of child from the proper court. D. The child can claim the maintenance till the father gets the custody of the child. In the same case, it was also observed that the husband can get rid of maintaining his wife if he proves that the wife refused to live with him without any genuine cause. C. Father or mother. The third categories of the person who can claim the maintenance under this law are father and mother. The parents must be unable to maintain themselves. This provision was incorporated in the law in year 1973. Here, the father or the mother is to be maintained by his son if they are unable to maintain themselves. The Supreme Court in Vijaya Manohar versus Kashi Rao Rajaram Savai observed that the section 125 restricts it to only the son, but the parents can claim the maintenance from their married daughter also, provided court is satisfied that the daughter has independent means of income of her husband. Section 125, subsection 4 discuss the conditions under which the maintenance allowance can be granted or can be refused by the court. They are: A. The court can refuse maintenance if the wife is living in adultery. The basic aim of the section 125 is to safeguard the interest of wife and protect her from desecration, etc. The act of adultery is the breach of matrimonial trust between husband and wife, but living in adultery does not mean a single act, but when she is continuously doing this act. B. When the wife refuses to live with her husband without any sufficient reason, the reason to live separately should be reasonable and just. Disagreement with husband's family is not a sufficient cause to live separately and claim maintenance, but the Supreme Court in Dev Chand versus State of Maharashtra said that marrying the second wife by husband is a sufficient cause for the wife to live separately. Similarly, the Supreme Court in Ashok Kumar versus 6th Additional Session Judge Varanasi held that the impotency is a ground for women to live separately and claim maintenance. C. The maintenance cannot be awarded to the wife if she is living separately by mutual consent. Living separately must be the outcome of independent desire of the both parties. If a husband keeps a mistress and the wife resides separately, it cannot be treated living separately by mutual consent. Monthly allowances. Section 125 lays down that the husband or father has to pay the monthly allowance to the parties when ordered by the court. In the initial stages, it was Rs 500 per month, but after the amendment of the law, the discretion has been given to the magistrate to fix the monthly allowance, keeping in view the status, income and other things of the person directing to pay in consideration. Non-compliance of the order. When an order of maintenance is passed and the person fails to comply with the order, the magistrate has the power to proceed under section 125, subsection 3. A. The magistrate can issue warrant for levying the amount due. B. Sentence the defaulter to imprisonment. C. The magistrate may for every breach of the order issue warrant for levying the amount due. But before passing any such order, the magistrate has to see that the failure was not deliberate or without any sufficient cause. The above order will be passed only when the aggrieved party applies to the magistrate and the limitation period for it is 1 year from the date it became due. Section 126 lays down the procedure for the grant of allowance under Section 125. Section 126 reads as: Number 1. Proceedings under Section 125 may be taken against any person in any district: A. Where he is, or B. Where he or his wife resides, or C. Where he last resided with his wife, or, as the case may be, with the mother of the illegitimate child. Number 2. All evidence in such proceedings shall be taken in the presence of the person against whom an order for payment of maintenance is proceeded to be made, or when his personal attendance is dispensed with, in the presence of his pleader, and shall be recorded in the manner prescribed for summons, provided that if the magistrate is satisfied that the person against whom an order for payment of maintenance is proposed to be made is wilfully avoiding service or wilfully neglecting to attend the court, the magistrate may proceed to hear and determine the case ex parte and any order so made may be set aside for good cause shown on an application made within 3 months from the date thereof, subject to such terms, including terms add to payment of costs to the opposite party as the magistrate may think just and proper. Number third, the court in dealing with applications under section 125 shall have power to make such order as to costas as may be just. The law further lays down that the order of maintenance can be altered. Section 127 empowers the magistrate to increase or decrease amount of maintenance due to the change in any circumstances. When an order of maintenance was passed on the basis of a compromise, still the court can change it once the parties want it. The order under this section can be passed only if there is already an order passed under section 125. Change of circumstances is a relative term and it depends on many factors such as income of person, etc. Change of status here means the financial status. Section 127 subsection 2 lays down that the magistrate has the power to cancel or change any order passed by him under section 125 if any civil court has passed any order contrary to the order under section 125. Subsection 4 of section 125 has laid down that when a civil court makes any decree for recovery of the maintenance or dowry, they will consider the amount of maintenance paid by him under the order passed under section 125 of Criminal Procedure Code. If under section 128 subsection 2 any order of cancellation of maintenance is passed, it will have prospective application and will not apply retrospectively. How the order of maintenance is enforceable? The section 128 of Criminal Procedure Code lays down the procedure for enforcement of order to maintenance. The order of maintenance, interim maintenance order or an expenses proceedings passed can be executed by the magistrate who has passed it in his jurisdiction or by the magistrate in whose jurisdiction the person is living. The order can be passed in any place and it includes place outside the jurisdiction of the magistrate. Jurisdiction of the magistrates. The maintenance proceedings under section 125 can be initiated against person in any place A. Where he is living, B. Where he or his wife is living, C. Where he last resided with his wife, with his children or parents. The Supreme Court in Jagir Kaur versus Jaswant Singh said that the language of section 126 subsection 1 should be interpreted liberally without doing any injustice. With this, we come to the end of today's topic. Hope you have understood fully. Thank you for watching.